This is your first multi-voice time writing at 140 words per minute. Your proper names are First National Bank of Denver, Leonard J. Hoffman, Mary Ann Hoffman, Civil Action Number 86, CV 8298, James Barton, Mr. Hoffman, Meadowlark Court, Honda, Leonard and Paulette Hoffman, Ferguson Finance, First National Bank, Garden Ranch, El Paso County, Honorable Donald E. Compton. I just wanted to point out something on the civil action number, that cause number. Usually in court, they'll say 86-CV-8298. So, you would hit the HF or hyphen, but I don't know if you want me to read it.
Mm-hmm.
Yes. Okay. So I will be saying dash, but just remember you're going to hit HF on your machine for the hyphen, because in reality, a dash is two hyphens together. So although they say dash, it's actually the hyphen mark on your machine. Are those on over there?
Yes.
Okay. I am Mr. Barton.
The witness?
The court.
Mr. Barton.
The witness.
The court.
It is going to begin with colloquy by the court.
Okay, this is in the matter of the First National Bank of Denver, a national association, plaintiff versus Leonard J. Hoffman and Mary Ann Hoffman, defendants. Civil action number 86-CV-8298. Appearing is the co-defendant Leonard J. Hoffman and counsel for the plaintiff James Barton. Mr. Barton, you may proceed with your examination.
Thank you, Your Honor. Mr. Hoffman, I show you a warranty deed and ask you if that is the deed to the home, which is also known as 1845 Meadowlark Court.
Yes, it is.
Whose name does that deed depict?
My name and my wife, Mary Ann Hoffman.
Is that home in foreclosure at the present time?
No.
The payments are current?
Yes. There are liens on it, however.
Do you know approximately how much in liens?
About $16,000.
Is there any equity in the home?
If I sold it right now, there would be just enough to pay a real estate agent his commission, and that's about all.
Now, I direct your attention to the automobile registrations, which you have brought here today, and look at one for a 1984 Honda four-door automobile titled in the name Leonard and Paulette Hoffman.
I told you before this started that the Paulette was a mistake. It should be Mary Ann.
Okay. How much do you owe on that automobile?
I think it's about $5,400 or something like that.
Who carries the financing on that?
Ferguson Finance.
What efforts have you made to pay the judgment that First National Bank has against you?
None at all, because I don't feel it is fair.
Are you willing to make some effort to pay $200 a week out of your salary?
No, I am not.
Your Honor, I request perhaps a direction from you at this point. I believe you have the power to make such orders. Do you not? That property is not exempt. He previously told us he gets about $500 per week. I have a valid judgment.
Take taxes out of that and food and shelter, and that leaves about $65.
Let me clarify. You are talking in terms of salary now.
Yes, Your Honor.
No, I believe your proper remedy is your writ of garnishment, if I am not mistaken.
Did you bring your check stubs with you today?
No.
Are you paid by checks with an attachment?
Yes.
Is withholding taken out of your salary checks?
Yes, it is.
Mr. Barton, may I interject? I hate to interrupt your train of thought, but I forgot to advise you, Mr. Hoffman, that you were put under oath last time. This being a continued hearing, you understand that you are still under oath?
Yes, sir. I assumed that I was.
Please continue, Mr. Barton. Excuse the interruption.
I direct your attention to that financial affidavit which we went over the last time we appeared before Your Honor. Do you recall that document?
Yes, I do.
On that affidavit, you list a piece of property in the Garden Ranch subdivision in El Paso County.
It's just a vacant lot.
Now, it is your position that you don't think the judgment is fair and therefore you don't intend to pay it?
Right. I feel like I'm being railroaded.
Well, the matter is now academic at this juncture.
Let me make a statement here so we don't get into an argument. I would have to agree with Mr. Barton that the matter is now academic. Judgment has been rendered against you.
Sir, all I asked of these people was an itemized statement of what they believed I owed them and an explanation for some charges that I felt were out of line. No one in the bank came forth with anything like that, so I took the balance from the papers that were given to me at the time.
This is not the forum for you to argue about how much you owe or do not owe.
I realize that.
I see from a default judgment duly signed by the Honorable Donald E. Compton that the defendants owe the plaintiff the sum of
This is your second multi-voice time writing at 140 words per minute. Your proper names are Mary, Mountain Knolls Property Owners Association, Mountain Knolls Joneses, Mr. Gleese, Mr. Jones, and Spanish. I am Mr. Smith.
The witness?
Mr. Capstein.
Mr. Smith.
The witness.
Mr. Capstein.
It is all colloquy, and it is going to begin with Mr. Smith. Me. Where is it? Is it right here? Or where?
Yeah, right here. Starts.
Oh, ready? So go easy on yourselves and settle.
No way, we can't.
Why?
For 50,000? Come on, he'll owe me 20. He's paying on time. His business has gone to pot. He's paying alimony and other expenses to his wife. He's not a kid anymore. What are you, 63? He's seen his best days financially and in general. I'm giving him a break. Obviously, you guys aren't.
You don't just climb over your neighbor's fence one night while he's away and topple every tree on his property.
I've met with your client how many times, I don't know. I've begged him. I've appealed to his sense of decency. Nothing works. Before Mary left me, she baked some wonderful cookies and I personally took them to his front door. Nothing. I've sent him the bylaws of the Mountain Knolls Property Owners Association, where it specifically states that any tree or obstruction to a neighboring home is against the rules of the association and will be held up in court.
That law was allowed to run out 2 years ago due to the association's inaction. Your association is not a major force in Mountain Knolls anymore.
But these laws were previously held up in court and have preserved the nature of the area until people like the Joneses found a hole in the law.
Which would have been a wonderful defense, but Mr. Gleese decided to take matters into his own hands. The same money you're spending now could have been spent getting my client to cut down his trees. And if that didn't work, then maybe you go to these lengths. I don't know.
I couldn't take the risk. I didn't have the money.
And so here you sit. Did you possibly think you could get away with it?
I advise you to let me answer that. My client, due to adverse conditions, especially in light of your client's attitude.
He is a rude man, Mr. Jones. She's not much better. I tried to approach her one day. All she could say is, "It's our property. We'll do with it what we want." Basically, go take a hike. Both of them.
That's conjecture. I want that stricken.
No way. It's a fact. They have not shown an interest in dealing with my client. They won't negotiate, which is why he took the action he did. No way.
I've never been around more rude neighbors. They haven't talked to me for almost a year. They walk away from me when I attempt to appeal to them. Who do they think they are? What's with this new generation of people? They move into an area and act like the rest of us are a bunch of idiots with no feelings, no rights.
Mr. Jones waved an amended association document in my client's face and told him he was powerless to stop him from growing his trees.
I used to water my lawn after work and stare out over my fence and watch the sun go down over the water. The sun would reflect off the Spanish tile roofs with the ocean in the background. I put in years of overtime to pay for that house just because of our view.
Then the tile roofs began to disappear behind the green foliage of your shade trees.
I'd have to get on my tiptoes to see any of the homes below, then pretty soon just to catch a glimpse of the water. You've never seen such a view in your life in the early morning on a beautiful Saturday morning. The purple blue water so still and quiet, the sun coming up over the city off to the side.
Eventually, Mr. Glees could hardly see the water from his living room windows. His windows are on a slope over the backyard, 2 stories up, and your client's shade trees started taking out his view from there.
Why tell us? We're responsible to our client's wishes.
What we're basically doing here is rehearsing for you the position we'll take before a jury of Mr. Glees's peers. Nothing irritates people and neighbors more than a condescending neighbor, new on the block, who
This stays on, right?
Can
I'll
we
just
start
pass
it?
Let me just pass it. This is your first multi-voice time writing at 120 words per minute. Your proper names are Notary, Mrs. Lawrence, Department 34, Mr. Crane, Roger, Hazel, and Mr. Morton. I am Mr. Ferguson.
The witness?
Mr. Crane,
Mr. Ferguson.
The witness.
Mr. Crane.
It is going to begin with colloquy by Mr. Crane. Ready?
I don't agree with you. I think it is immaterial, and I instruct the witness not to answer. Don't get me wrong. I don't want in any way to infringe on what you are entitled to ask.
Well, may we now have a stipulation that as to any question which you have instructed her not to answer, she will have been deemed to have been so instructed by the notary, and she in turn will have refused to answer on advice of counsel.
So stipulated.
And if I decide at the end of this deposition that we would like to cite Mrs. Lawrence to Department 34, you could appear in her stead for argument on that.
So stipulated.
Had you ever consulted a lawyer other than Mr. Crane about these payments which Roger was making to Hazel?
Yes, of course, I talked it over with Mr. Morton repeatedly.
That is, you talked to Mr. Morton about these payments?
Yes, Mr. Morton agreed with me.
I am not asking you what was said right now. I am asking you whether you talked with him.
Yes, I did.
Did you ever talk to him in the presence of Roger?
Yes, on one occasion that I can remember. Once Mr. Morton came to our house.
Now, can you place the time of this meeting?
No.
Could you at least place it in terms of a year, in which year it may have been?
No, I really can't.
You can't tell whether it was 1996 or 1995. Well, it wasn't 96 and it wasn't 95. It must have been before that. It has been more than once, you see. What did Mr. Morton tell you these payments were?
Do you mean the amount?
That is rather ambiguous. I will clarify that. Did you ever tell Mr. Morton that you wanted Roger to pay only $500 a month to Hazel?
Yes.
Was this in Mr. Morton's office, or was it in your home?
In several places.
That is, that you told Mr. Morton on more than one occasion that all you wanted Roger to pay was $500 a month to Hazel?
Yes.
What did Mr. Morton say to you when you told him this?
No, we don't want hearsay.
That is not hearsay as to her. It may be hearsay as to my client, and I am waiving that privilege. It is not hearsay as to her.
I don't claim to be an expert on procedure, but I believe that is hearsay.
Well, if I ask her as to any conversation that somebody else may have said outside of her presence, she could object on the grounds that it would be hearsay. But when I am asking what conversation she had and that she took part in, she certainly couldn't object to it being hearsay.
As a matter of fact, I have no objection to your knowing the advice that Mr. Morton gave her.
I want to know that.
Don't forget this, that Mr. Morton was apparently the attorney for both parties.
Well, are you now objecting on the ground that it is privileged? That may be a legitimate objection. If you say that it is privileged, you may be right, but not on the grounds of hearsay.
I also believe it is objectionable on the ground of privilege. I believe he was, at that time, acting for both of them. He is a personal friend, apparently, of the two of them. I believe it would be good on that.
I think perhaps
And it continues. You read your question, the whole answer.
You're like a whole paragraph.
it's so funny over there.
You read like a whole
I'm sorry.
It's okay. No problem.
I was like, why did we have the giggles over there? Okay. This is your second multi-voice time writing at 120 words per minute. Your proper names are Mr. Crane, Hazel Lawrence, East, and Roger. I am Mr. Ferguson.
The witness,
Mr. Crane,
Mr. Ferguson.
the witness.
Mr. Crane.
It is going to begin with colloquy by me, Mr. Ferguson. Ready? I think you are right if you raise the question of privilege. That would be good, but I still maintain that on hearsay it would be improper. Of course, you know, Mr. Crane, that your client may waive that privilege if you desire.
Yes, it is true. However, I don't want her to waive that privilege.
All right. Has Hazel Lawrence ever written you?
I don't remember.
Could she have?
She might have when she was in the East.
How many times would you estimate you have written her?
I wrote and told her how the children were when she was East that time.
I am not asking you what you said. I am merely asking you how many times you wrote to her.
I don't remember.
More than once?
Yes,
4 or 5 times?
maybe. I don't remember.
Those were friendly letters?
Well, I told you what I was trying to do.
Those were friendly letters, weren't they?
On my part, they were. I was trying to make a better relationship and trying to make my life a little bit more bearable, but I didn't succeed.
These letters were written after the expiration of the settlement agreement between Roger and Hazel.
I don't remember.
Well, if I tell you that Hazel was in the East in the period between February and March of 1993, would that refresh your recollection?
Well, if you say so and you know it, I don't remember.
In those letters that you wrote to Hazel during this period, you didn't say to her then that you were objecting to these payments that Roger was making to her, did you?
I told you what I was trying to achieve.
You were trying to achieve what?
What I told you.
Friendliness between the two families?
For the sake of Roger and his children, and for my sake too, because my life was horrible the way it was.
You knew you couldn't achieve that by asking Roger to cut Hazel down to $500 a month?
I believe you are arguing with the witness. Are you not, counsel?
Well, are you objecting to the form of the question then?
I do object on the ground that it is argumentative. You can reframe it, of course.
All right. It was at this period of time that you were trying to adjust whatever differences there may have been between the two respective families, were you not?
I was trying to do what I said, to make it so that Roger could see his children and they could come to see him. He wouldn't have to go up there day after day and come home furious and make my life a hell on earth, which he was doing, and that is what I was trying to do.
How often would Roger go to visit the children?
Well, 3 or 4 times a week.
As a matter of fact, during this period of time when Hazel was in the East, Roger was still paying her $428 a week, wasn't he?
I don't remember the time. You are the one that remembers.
Well, I am just asking you for your best recollection.
At that time, of course, if that is what it was, I couldn't object. That was the legal agreement. I had no right to say anything until that expired.
One further thing, Mr. Crane, that I have forgotten to mention in the beginning. I presume it is stipulated that any objections I may have as to non-responsive answers of the witness or conclusions may be reserved to the time of trial, and I believe it will be so stipulated.
Correct.
Have you ever made demand upon Hazel of the return of these funds? And recording, right?
Mhm.